instill or to instill justice in this case. The letter also stated that there was no illegal activity. It also stated to Jennifer Granholm so that she would not be able to say that she didn't know what her staff was doing in this case. And we informed her that any witness tampering had to be reported to the federal government. The law is Title 18, Section 1512. Any witness tampering must be reported to the federal authorities, and if you don't report it to the federal authorities, it's a felony of itself. She covered this up. She didn't report it to the to the federal government, and as a result, she committed a felony, which is called misprision of felony. You cannot attach yourself to a criminal conspiracy and fail to interrupt that conspiracy and don't report it to the federal government. Okay, and this is the letter that was sent to her. It's clear. It explained and described what had happened during the testimony. It clearly says that if she is not a co-conspirator, that she would investigate this and cooperate without prejudice or reservation. And apparently she was a co-conspirator in this, because she knew about this case. She made press conference about this case. And everything that went out in terms of the charges by the other prosecutors had her name on the letterhead as being the chief law enforcement officer in the state of Michigan. Okay, this document, a similar document was also sent out to Mike Cox after Jennifer Granholm went to become the governor. The issue here is that absolute immunity can be denied a person who's a prosecutor that have a conflict of interest. In other words, if they stood to gain by charging a person with a crime and that the person did not commit, okay, then they could be denied absolute immunity. In this case, it was a conflict of interest because Jennifer Granholm was running for the governor's seat, and she charged us with the crime, and it benefited her because it got her media exposure and it got her political clout such that it helped her to get elected based on the attempt to cause our demise. Okay, so it's conflict of interest. It was based on no facts that there was a belief that we had committed a crime, yet she charges. In both instances, I showed you the documents that proved that they knew that we had not committed a crime and charged us anyway. And again, for absolute immunity, once you know that the person didn't commit the crime and you have no probable cause, then you cannot be a true advocate for the state and you're not entitled to absolute immunity. Okay. This document also includes the statements of all of the staff that worked for Clarence Jones and Complete Care Medical, and all of the staff said that we never heard Dr. Whiteus give Jones permission to use his name in any capacity. That's every person. Jones testified in May 29, 2002, and this is the document that clearly talks about what Jones testified to, and it's clearly stating, based on Jones' testimony, that he sent someone to get my approval to use my name, but they never returned to tell him that I disapproved. In other words, he was never told it was okay by me to use his name, because the person that he allegedly said he sent to get my approval never came back to tell him it was okay. Now, to analyze that situation, one can conclude if he asked someone to get my approval, then clearly he didn't have it. If he had my approval, he would never have had to ask someone to get my approval. And that's in these transcripts here. The other thing is that if she never came to tell him, and that means he never talked to me. So you can't have a conspiracy if you never met with the person, never talked to him. You have to have a meeting of the minds, and you have to have some form of communication, whether it be direct or indirect, such that there is an implied agreement or an implied arrangement. That is the definition of a conspiracy, and also you can be charged with conspiracy if the evidence is circumstantial. But if you don't have any communication, nobody ever communicated, you can't have an implied agreement. You can't have any kind of arrangement if there's no verbal communication of any sort, or any communication of any sort that there was an agreement or that may have been illicit or illegal. Okay, and the state prosecutors and investigators knew this. Okay, that they never had any agreement, and they didn't have a statement. Jones refused to talk to these police officers in the initial charging of this case, and did not give him any kind of statement. The police did not give the police any kind of statement until the middle of April of 2002. And at that time, his testimony was coerced with evidence that was inserted and was told or instructed to him to give testimony against the accused fraudulently. Okay? And thus again, with that fraudulent testimony given by Jones, the prosecutors, investigators knew that Dr. Whiteus had not committed a crime, and again, they weren't entitled to any form of absolute immunity. Okay, and that's what this document, okay, states. And now we're going to go on to some other documents because we got a lot of ground to cover here. After the testimony of Clarence Jones, who turned state evidence, fraudulent state evidence against the defendants, myself, Dr. Mitchell, and Dr. James, I wrote an article that described what happened, and it talked about the illegal targeting, the racial profiling by the State Attorney General, Jennifer Granholm. And this article was written by myself. It was written July 9th of 2002. And so this particular document here explains that we were charged with crimes that we hadn't committed, that they had no probable cause or evidence that we had committed a crime. It asked the question of what they knew before October 18th and 19th, which was the date that the initial preliminary exam commenced, and that's October 18th and 19th, 2001. What did they know before October 18th and 19th? What did they know after 18th and 19th? Well, what they knew before October 18th and 19th was that Dr. Mitchell gave a statement clearly giving material fact evidence that there was no crime committed, that the money in the envelopes was legal, and that there was no conspiracy. They also knew by their computer investigation that Dr. Whiteus hadn't signed for any person to bill in his name illegally. That would have been Clarence Jones, Complete Care Medical. They also knew that Jones had not given them a statement, so they had no probable cause statement from Jones to even form a factual belief that a crime was committed by Dr. Whiteus. And also the next thing is that they had no evidence based on any fraudulent claim that they could have charged against me in terms of that I would have even attempted to submit fraudulently to gain reimbursement. So they didn't have any of these three components that was necessary for them to have probable cause or to form a factual belief that I had committed a crime, yet they charged me anyway, knowing up front that I hadn't committed the crime, and thus again absolute immunity should be barred from all of the state prosecutors, because they were not a true advocate for the state, because there was nothing to advocate, because there was no belief that a crime was committed, and they knew the documents support that. Okay, and so this statement here clearly shows, okay, what happened, and they'll be scanned for your perusal, and we're going to move on to the next document. On February 5th, 2001, I granted the Michigan State Police, as well as Scott Van Treese of the Health and Human Services, he was a federal officer with the Inspector General's office. I granted them an interview where we met at my office on Davison and in Detroit, and we sat down and we had a conversation. And in that conversation, I indicated to them that I had created a